Good morning, sir. You are Asa Joseph Jones. In cause number 25, DCCR 0963, you're charged with aggravated assault, discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
No.
And do you want to reject this offer and have your case set for trial?
No.
All right, I'll get that done. As far as you know, all the discovery, you have everything?
I have everything.
Okay.
And we're not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand?
Yes, no.
Okay, we'll get it set for trial. Mr. Burbank will begin preparation. Thanks.
I'll be happy to see you. Is it?
And then you have Kevin Ross.
Yes, Your Honor, I just sent the paperwork.
Okay, I'll take care of it in just a second. Let's get Calvin Randall. I can take care of Calvin Randall for Mr. Eckhart.
You'll need to get fingerprinted.
We're just going on 2.
Yes, ma'am. Yes, ma'am.
529.
This is
Thank you. I'll need, can you do one for each? It's easier for them. I'm going to mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 1530. I need to write 1530?
Correct. Yeah, 1530 is what that one needs to be. And we're going on multiple counts.
They can both be counts one on the judge. Because they don't get 10.
All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for. IATWFZ.
That's the statutory name, Judge. I think it's in a correction facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
I've seen that before.
Weapons-free zone.
That's what it is.
Thank you, in a weapons-free zone. All right, and that is from May 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in cause number 24, DCCR 1530, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. And in cause number 24, DCCR 1529, find you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do, I don't think 1529 came through. Would you?
Yes, ma'am.
They're gonna, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. I don't know what's... All right, thank you, sir. You can go back with the bailiff. We'll get it to you. Morning.
Good morning.
Good morning. And sir, you're Larry Fletcher Jr.?
Yes, ma'am.
And Mr. Fletcher, in cause number 25, DCCR 0838, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0839, you're charged with the second-degree felony offense of manslaughter from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, in cause number 21, oh, so we've got a motion to revoke probation in that one. Okay.
Okay, what I do is just go through the motion at this point. I think Mr. Holman said that he would rather proceed on the MTRP first.
Well, the MTRP is based solely on these allegations.
So it would be a whole trial.
Yeah. Additionally, if the MTRP was adjudicated prior to this case going to trial, arguably it could foreclose an application for probation by the defendant, so.
Yeah.
That, I'm not worried about that, because if it,
Either.
no, I guess I just don't want to. What level offense is that possession? Hold on a second, let me go back here. Second degree. Where's Mr. Coleman
I'm not sure.
to get ready? I mean, a lot of times I want to do the motion first, just because it depends on what the allegations are. I don't want to try to have to find 2 days for a hearing and hear all the evidence that we're then going to have to turn around and potentially hear in a trial if it's not likely to be dispositive. I don't. Look at one more thing. Hold on. Yeah, on this one, I don't know that that makes judicial economy sense. So what I'm inclined to do is set those for trial. But let me do this. It looks like the state has offered you in those two cases an 18-year term in prison. Mr. Fletcher, I have a plea bargain rejection that has your signature on it showing that. And that would be 18 years in each of those cases to run concurrently. Is that your understanding of what their offer is?
Yes, ma'am.
And you understand if you go to trial again and you're found guilty, the range of punishment can be up to 20 years in prison. Do you understand?
Yes, ma'am.
I do want to go ahead and do this, and then let's go through the motion. I do want to get pleas of true or not true on that motion, and then what I'll do, Mr. Wilkerson, is get with you and Mr. Coleman in the next week or so. He's got a trial this week that he's getting prepared for, and I will make a decision on whether or not I'm going to go forward on the motion or if we're going to set those cases for trial first. But I want him to be able to have at least his argument in that, so we'll do it that way. So let me go through and find the motion real quick. And Mr. Fletcher, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. So in cause number, there we go, 21-37809. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 11th of 2021 for the second-degree felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of manslaughter on September 18th of 2024, and is that true or not true?
Not true.
Count 2 alleges that you committed the offense of criminally negligent homicide September 18th of 2024, and is that true or not true?
Not true.
Count 3 alleges that you committed the offense of aggravated assault with a deadly weapon September 18th of 2024, and is that true or not true?
Not true.
Count 4 alleges that you committed the offense of possession of marijuana on July 4th of 2023, and is that true or not true?
True.
Count 5 alleges that you committed the offense of unlawful carrying a weapon on July 4th of 2023, and is that true or not true?
Not true.
All right. Did you enter your plea of true to count 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 4 freely and voluntarily, find that count true, find sufficient evidence to find you guilty and revoke your probation. However, what I'm going to do is reset this for now. Just make a note for me to decide what I'm resetting it to and put it on my desk, and I'll get an email or a call, Mr. Wilkerson, with you and Mr. Coleman within the next couple of days, and we'll figure out if I'm going to set it for a hearing and what amount of time that would need on the motion, or if I'm going to set it for trial on the new cases first.
Okay.
All right? And we'll stay in touch with Mr. Wilkerson and your bondsman, and they'll let you know when you need to be back, and he'll let you know what it's going to be for and all of that.
Yes, ma'am.
Okay? You're free to go. We need a print, please.